My name is Greg Brandis. I am the CFO and COO, Monterey College of Law. It's my great pleasure to be with you tonight to chat about what law school classes are like. Now, it's a fair question. Why would I be the guy talking with you about this? Never fear, I was a law professor for a lot of years. I was dean at law schools for a lot of years. And then I went over to the dark side, the administration, which those of you who work, anybody ever worked in academic settings, they all think we're, evil. All the professors think we're evil. So that's where I am now. But lots of experience and many times actually doing this program with my good colleague, Professor Ray Chow, who's here with us tonight. Welcome, Ray.
Hi, everyone.
And also joining is Don Yashiro, who I imagine most of you know from conversations over a period of time, as you've been taking a little bit of a look at law school and perhaps our law school. And we are very, very pleased that you chose to take some time and spend it with us tonight to see what a law school class is like. So we are going to do what we can do within a short period of time anyway to sort of simulate the experience for you. You might at the end of the day say, this is really cool. I think this is going to be a lot of fun. You might not, but usually after we get through, most people say, I would like to do that a few times a night for a few years as I do my law school career. There's a lot of ways you can go to law school nowadays. Some of them don't involve live classes. Here at Monterey, we are committed to that model as part of our educational mix because we think it really makes a difference. And I think you'll see as we go through tonight's session why it can make a difference in how you learn and the ability to sort of capture and gather and collect all this stuff and make it make sense to you and stick with you. So that's what we'll be doing tonight. We'll also have chances for you to participate if you want to. One of the things to remember about that is we are recording. This will be a posted kind of thing. So if you participate, you're consenting that your voice will be recorded in your conversation. And don't let that frighten you. We will make it a very comfortable experience. Professor Chow is expert at how that goes. My role tonight is primarily moderator. I will do a little bit of introduction to the law school, but also to kind of what we're doing, why we're talking about criminal law, that kind of thing. And then I'll turn it over to Professor Chow for the majority of the session. Then we'll come back at the end to answer any questions that anybody has about the law school, about the session too, but about the law school and the process and all the rest of that stuff. So that's kind of the layout of the evening. So Professor Chow, do you want to load up the slides for us and share?
Sure. Let me double check that this is the right screen. Okay. Does everyone see the slides?
I think it's coming.
How it's loading, probably.
Oh, okay. Is that the most recent one I sent you earlier today?
Yep. Mm-hmm.
Oh, it is. Interesting, because it has a different first slide. Oh, you're on your part. Oh, yeah. Can you go back to the
Oh, I'm sorry. That's why.
can
Right.
you go back to the beginning
Yeah.
for us? Okay, there you go. Thank you. So if you go to the next one, let me talk a little bit about why we chose criminal law for our class tonight. Now, criminal law is one of the oldest forms of law for which we have any real evidence that it existed. We can go back to about 2500 BC with actual physical evidence that there were written down criminal laws. And it's not surprising. I mean, unfortunately, when you put a bunch of people together, when you first sort of start gathering into societies, uh, things happen. When they get bad enough, somebody in charge has to set down some rules for how we're going to settle all this stuff. So we can actually find tablets and carvings and things like that that go back as far as 2500 BC with this particular kind of law. So it's very, very important. And in fact, of course, today in our modern, really complicated societies, it's one of the most important things that we have to kind of keep everything as orderly as we are able to keep it. Now, criminal law has interesting history because it began as what we refer to as common law. And now, today, it is almost exclusively statutory law. So, written by your legislatures, written by the legislators that you elect, and put into in codified form in the law. But until about the 1860s, 50s, something like that, we were relying on the historical record, essentially, of how people had decided things were crimes in the past. And so you hear us talk about common law crimes, and common law crimes is a phrase that just refers to the historical crimes that have been around a long time, and they had an historical definition that is, in most cases, very similar in the modern statutory versions, but with some interesting differences. And the reason why we teach you about the common law crimes is that criminal law is a state law matter for the most part. So as you look at the law of crimes in different states will have retained different parts of the old common law and changed other parts of it to some new concept. So in law school, we tend to talk about common law crimes as the underpinning. We teach everybody about the common law crimes so that they can then understand the statutory variations that have come along, which are similar but not identical. And so that's why there's a reference to both of those things that you'll see along the way. And in fact, Professor Chow will illustrate some of the differences between the common law definitions and the statutory definitions in our criminal law class tonight. The other thing to know as we jump in is that crimes are defined by things we can spot that happened. We call those elements of the crime. So if a person does a certain set of things, they may be convicted of that crime that is defined by that set of stuff called elements. So elements are always found in the facts of the case. And as you go through your class tonight, and importantly, as you go through classes in law school, what we'll be doing is analyzing example fact patterns, looking for the elements to see if what happened in the case might meet the definition of the crime. And we'll do that tonight, but in criminal law, that's what we do in law school. And we do it in other subjects in a slightly different flavor as well. But that's sort of the basic analytical process that applies tonight, and then in some other settings as well in law school. Much, much more that's interesting about the law that you'll learn along the way, but that's just kind of backgrounder for how why we're talking about criminal law. It's one of the most fun ones in a lot of ways. It's one of the easiest ones because it's elements based, and so hopefully you'll enjoy the conversation about it tonight. If you go to the next slide, Ray, if you don't mind, there's our overview of this evening. I'm sort of in the midst of the mini presentation right at the moment, and then we'll move to our class. And then, as I mentioned, we'll have some time for a little bit of information about admissions if there are questions about that, and then general questions toward the end. If you go to the next slide. You probably are already familiar with Monterey. I just want to mention one or two things that I think personally are terribly important about what we do. We will demonstrate tonight, I hope to you, that it's really valuable, really important for us for you to have a set of skills alongside legal knowledge when you leave. And those skills include the ability to apply your knowledge in a practical way, with integrity, with good ethics, lawyers' ethics. I know, smallest book in the world, but the Book of Lawyers' Ethics. I know the jokes. Um, it's actually a lot more complicated than that, and much more interesting than that, as a matter of fact, because of some of the interesting conflicts we get into with people's rights and balancing all that out. But at Monterey, we take all that very seriously, and it's woven through everything that we do. And you'll see it's woven a bit into tonight's conversation as well. In every single class in law school, you'll be looking at some of those implications. And of course, importantly, the practical aspects of how you go about doing your things. So I think that makes it terribly important for you when you try to go out and practice, but it's also part of what makes it, in my opinion, a really compelling type of degree. There are other things that just don't have, to me, as interesting that you might decide to study that just don't have, to me, as interesting kind of complications to them. So, all right, well, if you go to the next slide, let me also talk about how it works a little bit. Just as tonight we're getting together as a group, in law school you'll study in cohorts, you'll study in a group. You'll have peers and colleagues that you regularly get together with and tear apart these things. Our program is 4 years. It's part-time, made for working adult kind of folks. The faculty typically are all people working or practicing in particular fields that they are teaching or that they have had experience with in their practice or in other teaching settings over the years. A high emphasis on practical skills training. For example, you'll take a lot of clinical experiences while you're here, clinical and skills experiences. Those are intended to help you get ready to actually go out and practice when you get done. And so, very strong emphasis on that, stronger than you see at a lot of other schools, although others are getting more like us over time. But we've been doing that for a very, very long time. As I mentioned, we think that live classes like this are a really important part of things. It'll take you 20 to 25 hours a week, typically, to study for to do all your work, go to class, do your studies, and so on. So you want to be thinking about how you fit all that in. And then just to mention, the law school is accredited in two ways, actually. It's accredited by the Committee of Bar Examiners, the State Bar of California, and it's also accredited by the national accreditor called the Western States Accrediting Commission, a branch of that. And that's a very significant recognition, very difficult to obtain, that the law school gained a couple of years ago. So, well accredited law school for your choices, not accredited by the American Bar Association, but by two other accreditors. All right, Ray, if you don't mind. So here's just a word or two about what makes great law students, just for you to think about as you approach this idea of maybe going to law school. First of all, uh, we are really capable of helping almost anyone become a lawyer at these law schools. And I say that with great confidence. I've been at this now a very long time. There are people who are like genius, big thinker kind of folks, and then there are people who are just really good at working hard. They don't have to be a genius, and you don't have to be a genius to be successful in this kind of endeavor and to also be a great lawyer in practice. You do have to be willing to work really hard. Probably the big thinkers don't have to work quite as hard as the rest of us, but either will work, whichever way you might characterize yourself. The other thing that makes a great law student is your choices, and your choices and engagement. And those two things are tied together because your engagement is partly a choice, right? So when we say it takes 20, 25 hours, you got to really find the time to, embed yourself in it, to really make it part of what you're interested in and how you like to spend your time. If you do that successfully and you're therefore prepared for class, consistently engaged with it, and a good citizen of the law school, oh, that's what we think makes a really, really great law student. So my admonition is whatever law school you choose to go to, kind of make that commitment to yourself to make it the most powerful experience for yourself that you're able to make it. Okay, well, enough for me. Let's go on. Let's talk about criminal law. Professor Chow, take it away.
Great, thank you. Hi, everyone. It's really nice to see so many people with a interest in not only attending law school in general, but our wonderful law school. I think the other thing I would add is today is designed to kind of give you a glimpse into the way a class is run through technology, right? Because that's going to be important for your law school education, and we want to make sure you're comfortable with it. Most people do, by now have adapted very well to online, but of course, it's not for everyone. So let's keep that in mind as well. So in the course of this discussion on criminal law, and thank you for that historical introduction, because that's always relevant to legal studies. In every class, there's going to be a combination of kind of the practical statutory or case briefing and analysis. But I think to be a successful law student and a successful lawyer, you kind of want to know the foundational, historical, and the evolution of law, because the law does evolve every single day. If you look at the headlines, you see the U.S. Supreme Court will come down with a decision. That's the evolution of law every single day. Okay. I'm also going to welcome questions. If you would just raise your hand. I think I'm not really good at monitoring the hands, but I think I have enough support to help us, and they can maybe help get your questions or your comments. And I'll be posing questions. I think you've probably have heard that law school is usually very reliant on the Socratic method. And for those of you who are unfamiliar with the Socratic method, it's when the professor basically asks questions and then it becomes layered. So once you provide an answer, that prompts another question, another question, another question. And I think the reason why that method is so revered in law school is because the law is all about thinking. It's what's next. The answer is very rarely answered, right away. It takes more questions to answer questions. I always say it's like peeling an onion. Okay, and I think the experienced professors or the professors who have done this a long time, they're very good at that. Okay, and you too will become very good at answering those questions, but more importantly, also realizing that the answer will prompt another question in your mind. Okay, so let's start with burglary. It's one of my favorite crimes because actually criminal law is a great subject because we all live in the same world and we're all acutely aware, maybe too aware of crime in our society. But let's break it down a little bit and maybe you'll gather a stronger understanding of these crimes as they're viewed under the law and how they've evolved. As pointed out, common law is kind of historical. I like to think of it as man-made or court-made laws. The common law is just the historical court cases where a judge listened to the facts and they decided this is burglary or this is not burglary. And within that exercise is relying on the elements. Well, this element was met, this element was not met, this element is required, this element is not required. Okay, so that's how the common law kind of created laws, crimes in particular in our case, and how they evolve. Okay, so when we teach criminal law, we always teach the common law, which is the foundation, and then we always recognize that every state has a different penal code, and that will be the source of your state crime. So, for example, the California Penal Code will have a specific code for burglary and definitions that are derivative of the common law. Okay, maybe not exact, but sometimes exactly. Okay, so under the common law, the way we teach it in law school is the breaking and entering of the dwelling of another at night with intent to commit a felony therein. Okay, so it seems like a mouthful and it seems like a lot. And, it is. And surprisingly, you're probably thinking, well, okay, that doesn't seem that bad. But the problem is you're going to have to multiply this by thousands and thousands and thousands of different laws, right? Different rules. But you're going to get the hang of it. And we start with the common law. This is the way burglary evolved through the courts, going back to the early times of the colonies, actually. And you can see that when we refer to elements, this is broken down actually very nicely into the various elements. The first element is a breaking, the second is an entering, the third is a dwelling, the fourth is at night, and the fifth is with intent to commit a felony therein. Okay, does anyone want to chime in and maybe using your own common sense or your experience in society, how is it a little bit different nowadays? Or what strikes you as something that's unusual? Go ahead. I'm sorry. Yeah, go ahead, Vicky.
Yes, I guess the part about at night.
Yeah, very good, Vicky. Uh, if this was the bar exam, you would have passed.
Thank you.
Yeah. Yeah, and you can see how the law does have to evolve based on society. And Vicky's actually right, because if we were back in colonial days, right, we would say, oh, well, burglary, the courts decided that the at night element was important. And I don't know the exact reason why, but I can guess. It's probably because back then, light, the way they experienced light was very different from us, right? They either had candles or lamps or things like that. And I think the impetus was when you do something like steal, let's just call it steal, or trespass someone's house, it's actually um, harsher at night or more dangerous or more harmful to society, right? So the courts are probably like, yeah, when you do this at night, on the one hand, we have general theft crimes, right? Oh, you stole something out of my house, okay? That would be a general theft crime. But then at some point, the courts are like, hey, you know what? This happened at night, at dark, when the household was sleeping. We're going to add this crime. We're going to heighten this crime in the sentencing. We're going to call it burglary. And that has evolved into the common law requiring it to be at night. But now, fast forward modernly, okay, you can see how, like, that doesn't really make sense in our current society. Why does it have to be at night? Okay, some of it is just, maybe there's no need to distinguish between nighttime or daytime because the way we have electricity now, it's all the same. Or some it could just be the norms of society. Society says, well, we shouldn't punish someone more harshly just because it occurred at night. We should punish them the same way, whether they broke into your house during the day or at night. Okay, so that's a common law burglary. This is the exact definition you will learn in criminal law at any law school, actually, and it's also the way that you would study for the bar exam. Okay. Now, what kind of intent is required? We didn't really talk a lot about intent, and sometimes you don't recognize that intent is a very big part of criminal law and law in general. What does that mean? The way I like to explain it is the acts are obvious, right? If you kill someone, you pull a gun, the act of pulling the trigger, you shoot someone. You take a vase from someone's house. Those are very easily identifiable and based in fact, right? So intent is a little bit trickier because we don't want to punish someone solely for bad acts, right? In fact, that's demonstrated in criminal law because sometimes people do bad acts, but they're excused from criminal liability, maybe because of insanity, maybe because of infancy, maybe because of self-defense. There's a variety of excuses that would uh, absolve someone from criminal liability. But the intent piece is very important because what we're doing is we're saying just doing the act is important, but it may not be enough for all criminal actions. But the intent is what's missing. What do they have in their mind? I'm very dramatic. I say, what's in their heart, right? Do they have this evil intent? Do they have this bad intent? Did they want to cause harm? That's going to be the recipe for a crime, right? Not just doing the act, but what they have in their brain, what they intend to do. What was their goal? And then what about breaking into your own house? So if we go back to the common law, it doesn't say anything about breaking into your own house, right? It says the opposite, the dwelling of another. But we actually know modernly that you could be guilty of burglary of your own house, okay, in various situations. Sometimes it's tied to like maybe insurance fraud or whatever. But it just shows the evolution that at some point the legislature said, hey, this dwelling of another is too narrow. It's too limiting. Okay. And society wants to punish a larger swatch of activities. What constitutes breaking? We're going to see that as well. Does it mean you physically have to break down the door, or is pushing a window that's ajar open? Okay. Um, Also, this next point about entering a part of the home that they were told is off limits, that's probably more commonly, understood as trespass, right? Are they trespassing? And then finally, like, what about entering a business? Remember, the common law was a dwelling of another. Again, a little bit narrow. So modernly, the modern statutes for burglary are much broader. they're intended to cover a broader range of acts and activities. So here we look at the modern burglary. This is pretty much how statutes have evolved. So remember, the statutes look at the common law and they codify it. They decide we're going to make it a statute and it's going to be given a penal code, and this is what the law is going to be under our statute. They've reduced it to an illegal entry. So you see how that broadens this idea of breaking. The dwelling of other structure or other structure of another. We're not limiting it to a dwelling. At any time, we've removed the requirement at night with intent to commit a serious crime therein, meaning it doesn't have to necessarily be a felony. Okay, here's a bonus question. What is the how do we distinguish a felony from a misdemeanor? Do you know there's one bright line rule? Anyone want to venture? Okay, it's actually pretty simple. Felonies are crimes that are punished by more than a year, and misdemeanors are punished by less than a year. So it's really interesting because commonly when we think of felony, we think, oh, it's more serious. And in some ways it is because the punishment is harsher, but it's not like based exactly on the act. It's really on the sentencing, which again is very complicated, right? That's gonna evolve as well in time. Okay, People v. Colbert. For those of you, we did send out material in advance. It was a lot, so if you had time to review it, that's great, and if you didn't, that's fine as well. Feel free to chime in and ask questions. Just raise your hand, and we'll get your questions or comments. So this first case, Colbert, this is a way we analyze cases, and at first there's always a learning curve, but then eventually you're going to start being able. You're going to work this muscle. It's going to become natural to you. You're going to read cases and you're going to know exactly where to pinpoint. We talked a little bit about IRAC, IRAC. That stands for Issue, Rule, Application, and Conclusion. Okay, those are the building blocks of legal analysis. The building blocks of all legal communication analysis writing. Okay, no matter what you read, whether it's a memo, a brief, a motion, a court opinion, U.S. Supreme Court opinion, there's always going to be issue statements. There's always going to be rule statements. There's always going to be application, and there's always going to be conclusions. Okay, there's variations of it, but those four fundamental elements are always going to be present in anything you do in law school and as an attorney. Okay, they cannot be dispensed with. Okay, so when you are in law school, you learn how to brief a case, right? What's a case brief? It's basically a summary of a case, so that a month from now, you can just read your summary. You don't have to reread the case. And you can see how that's going to be very valuable, right? To build on your learning. And then also in practice, if you're an intern or a younger associate at a law firm, a senior partner might ask you to brief a series of cases so they get an understanding of the case law, because they don't have the time to do that. That's something that you can do as an intern or a young associates. So we'll start with the facts. Why are the facts so important? Because that's how courts make decisions. They look at the facts specific to the case, and every case has got different facts. I don't care if 99 out of 100 facts are the same. There's always going to be at least one fact that's different. The car was red, the car was blue. Does that make a difference? Well, yeah, maybe in a hit and run, right? Because it was at night. And then the argument is the red car is easier to see versus the blue car. So again, you want to look at the key facts and you want to use the facts to interpret the elements and the rules of law. Okay. One exercise that we do in criminal law, when we go back to the common law for burglary, we talk about it's got to be at night, right? It's got to be at night. So what's the hypothetical in class? Oh, it's sunset. It's dusk. Okay. So let me ask you, how would you, if you're a judge, now you've bypassed becoming an attorney, you're all judges now, okay? You're a judge and you're asked to decide whether someone committed burglary, okay? And for whatever reason, we're going to use the common law. Let's say the statute requires it at night, even though I don't think any do. So it's got to be at night. And the defendant says, oh, it wasn't nighttime, it was dusk. Therefore, the prosecution has not proven that element, therefore, not guilty. Okay. How would you, as a judge, what would you ask? What would you want to know? What facts would you look at to determine whether it was, in fact, if the facts satisfied that requirement at night? He says it's at dusk, right? And then you look at the police report and it was 6:55, but then you look at the Farmer's Almanac and it says sunset at 6:59. Okay. Okay, judges. No wrong answers because judges are never wrong. Okay, is it Brima?
Brenna.
Brenna. Oh, I'm sorry.
No, you're good. I think I
How
would
would
also look at the weather,
Oh, very good. Yeah, I hadn't thought of that. That's great. Right. Was it cloudy?
right?
Yeah. And maybe all day long. Was it sunny? In summer, days are longer. Great. I love that. Anyone else or Brenna, any other question you want to ask?
I would probably check if there was any kind of CCTV footage that might like give you a
Oh,
better
great.
understanding of what it looked like.
Great. Then the judge could actually make a factual basis based on that. Yeah. Great. Very good instincts. Does anyone want to venture a guess how traditionally, historically, judges kind of what was their barometer? You probably won't know this. I'll just tell you. They used to question whether or not you could see your shadow. That was like the historical benchmark, if you can see your shadow. Okay. Now we'll just ask Alexa and it makes our judges' lives much easier. Okay, so in Colbert, we want to know about the facts. Did anyone read it or remember? This is the guy. He's kind of a habitual thief, right? He's been convicted of four times of stealing money with an accomplice at kind of bodega convenience stores and in a gas station, and uh, he argued that he wanted to reduce some of the charges from felonies to misdemeanors. Okay. And does anyone can anyone venture guess why do you think that would be important for someone? He's already been convicted, he's already served his time. Or actually I shouldn't I misspoke. Yeah, he has served his time. Why does the defendant want to reduce his those prior convictions from felonies to misdemeanors? Why would that be important? Well, I'm glad no one knows because I guess none of you are convicted of felonies. Brina?
Maybe because felons don't have certain rights under the law. I know
Yeah,
he wasn't seeking to get rid of all of them, only two.
true.
Maybe it looks better, for
Yeah.
future
Well, I mean,
opportunities.
for disclosure, I'd feel much more comfortable disclosing one felony than three felonies.
Right.
So maybe it's a matter of degrees, right? I guess it depends on the job. There's probably certain jobs that, you know, they think felony gives you a little bit of character. So maybe they'll take one, but they don't want four. Okay. So then, you know, when you think about the facts, when you read opinion, obviously those are the most salient facts. But I think also it's up to you to kind of zero in on what facts are most important because a lot of it in practice is what element are you going to argue? From the defense, what element am I going to argue against? What facts support my argument? And from the prosecution, is like what facts support, meeting the element. So does anyone remember if you read the case, what were they looking at or what was the trial court's decision? So he basically wanted to reduce three of his felonies. They didn't say which ones. Oh, I'm sorry. He wanted to reduce two of the felonies to misdemeanors. They didn't say which one. One was for 300, one was 318, one was 3,000, and the fourth he didn't get away with anything. Does anyone remember what the trial court said? Now remember, in law school we deal primarily with appellate and Supreme Court cases because trial court decisions are not binding in the same way, and there's so many of them there, and they're generally not published. Whereas appellate court cases are generally published and they have authority. Okay, so at the trial court, does anyone recall? The trial court actually agreed with them on one of the case, or I'm sorry, denied based on his argument because his argument was like, hey, in these thefts, I was an invitee, I was a customer, or I was invited into these stores, and then the actual theft occurred by going to the back room into an office, right? So he said that not that element of trespass, let's say, was not met. But the trial court actually agreed to, in the sense that, yeah, that private area is not enough to satisfy the element. But then on appeal, the appellate court disagreed with the trial court and said, no, that's incorrect. And they focused in on the fact that in a convenience store, you're invited to the general area, but you're not invited to the private office. So that was sufficient for the, let's say, breaking in this case, or the trespass. But the court also gave another reason for it, was that even though when stores are open, you're invited as guests, stores will never invite someone to commit a crime. So they made that other argument as well in their reasoning. Okay. And you can see how the tension comes in is when you apply the facts to the common law versus the modern law. And you can see how it evolved, because we're going to want to punish people who do things like that, right? You come into my convenience store and then your accomplice is kind of distracting me, and then you go into the back room where you're not authorized to go to, and you take my money. Okay. The next case is focused on robbery. And just as a preface, robbery is basically a heightened, or you can say aggravated, although it's not technically the correct term, but it's a heightened theft. And theft broadly is larceny, okay? And larceny requires you taking something from someone with the intention, remember, it goes back to what they had in their hearts, with the intention of depriving them of that property for good, permanently, okay? Um, and robbery is basically builds on larceny. And again, we want to punish them more harshly because robbery requires force. You actually force or threaten, or you intimidate someone in order to commit the theft. Okay, so you can see how, as a society, we're going to punish that person much more harshly. Okay, um, and force is often litigated because the defendant's going to argue, no, there wasn't enough force, or it truly wasn't force, or it didn't meet the element. Do you see this pattern here? How we've established the required elements, and the prosecution is going to say these are the facts that satisfies the elements, and the defense attorney is going to say, no, these are the deficiencies, because the prosecution has a burden of proof. Any deficiency in any element should result in an acquittal, right? You can only convict someone if the prosecution proves all the elements beyond a reasonable doubt. Okay, let's talk about this case a little bit. It was just purse snatching. I think what's really interesting about purse snatching is it really defined what force meant. There's always a need to define what the statute says, because statutes are not easy to write. And a statute could say by force. And the question on appeal is usually, what do they mean by force? Does it mean I physically have to snatch it? Or can it be something as simple as a pickpocket, right? Because that's what kind of happened here, is he basically slid the wallet without yanking it or using any sort of sufficient force. And under the common law, a lot of judges were saying, well, the only force that's necessary is kind of the force necessary to remove the item. But then modernly, we have this robbery statute, which is going to be a felony and treated much more harshly. The language opened up conversations like, well, force, the defense, like, I didn't put her in fear. I didn't threaten her. She didn't even know. I think that's the thing that is very interesting. Can you be convicted of robbery when the victim didn't even know you took the item, right? You took it out of someone's backpack and they were unaware of it, right? Is that sufficient for force, or is it only sufficient for just larceny or theft, which would be a lower charge? Okay. So if those of you who review this, it was basically she had a pocketbook with money, and he kind of distracted her by acting as if he was going to ask her a question, and he just easily slipped it out of her, it was kind of under her arm. And so his argument was there was no force. Now and the court said at that point, they said, well, the force has to be sufficient to not only does the victim have to realize it, but they distinguish it by it's the force against the force is vis-a-vis the property. I mean, not versus the property, it's versus the person, meaning the person really does have to feel the force or be intimidated or in fear. Okay, so let's use that basis and apply it to this fact pattern. Margolis approaches the stop car, waves a gun, orders the driver to leave the car, and drives off. The car was found a short distance away, undamaged. Margolis told police she only meant to test drive the car and left it when she was done. She was severely impaired with alcohol when she did this and thought it was a funny way to test a car. This is a great hypothetical, and this is the way hypotheticals, you can tell if it's written well, is it's going to be very concise, but it's going to raise a lot of discussion with a lot of elements. Can anyone identify an element that they're going to argue or they're going to say proves an element that's required under robbery? Let's start with the force or threat or intimidation argument. What factor is the prosecution going to argue on? Brina?
That waving the gun constituted like inflicting fear.
For sure. Coupled with stopping the car, it's forcing them, waving the gun, ordering, right? Ordering. He didn't say, oh, please. He ordered the person. That's definitely going to be sufficient for force, right? Force, threat, intimidation, right? Drove off. Is that enough for permanently deprive? Arguably. We're going to talk about that in a little bit. Oh, Vicky, were you going to suggest something? Well, the defense can argue, no, I said, you remember intent, it's what's in their head. No, I just did it for a joyride, right? Is that going to be enough? We're going to talk about that in a little bit, okay? The alcohol is going to be a defense. It could be beyond the scope of today's discussion, and the fact that she kind of thought it was kind of a joke, okay? So let's think about her intent, okay? Before we get to carjacking. So let's think of her intent. And then let's put it under the modern carjacking kind of statute. In carjacking, the legislature is expressly broadened the scope, right? In two ways. The first way is whether it was to permanently deprive or temporarily deprive, right? That's an expansion of the common law and the modern statutes, which was, there had to be an element of wanting to permanently deprive them. It doesn't matter if they actually did permanently deprive them, but it's the fact that they intended to, okay? And then the other way they broaden it quite significantly is it could be from the driver, the person, the owner of the car, or a passenger, okay? And you can see how that evolved modernly, because what if the driver is at a gas station, leaves the keys in the car, goes into the gas station to buy a drink, and then defendant takes the car. He says, no, I didn't take it from the owner. Okay, so that's why the statute contemplated that. It says, no, because there was a passenger in the car, right? So that's going to be sufficient. So you can see in this evolution of crime, we've gone from larceny, it evolves to burglary, it evolves to robbery, and now it's modernly evolved to carjacking, because carjacking is a relatively recent crime. I think probably the 70s or 60s, the legislature started implementing carjacking. So it's relatively new. Because why? Because society said, hey, we can charge you under a robbery, but you know what? That's not enough. Because when you take someone's car and it's all tied into constitutional law and privacy and how we want people to feel safe, we do generally feel safe in our car, right? It's a bigger breach than just taking a purse from someone out of their backpack, right? You've invaded their privacy, okay? So now a lot of times we want to compare laws. In real life, you're going to be charged with both robbery and carjacking, but in law school, we want to get into the nuance. What are the distinctions, right? What are the differences in terms of the elements, and then how do the facts play? We want to compare the carjacking to robbery, and there are some differences, right? As discussed, carjacking is much more specific, but the way I like to think of it is you have this umbrella of theft, and then you have a subcategory of robbery, and now you have a further subcategory of robbery, you have carjacking, right? It's a specific property, a car, and it's going to have its own kind of elements. It doesn't have to be permanent, it could be temporary. So that would cover joyriding. And it doesn't have to necessarily be the owner, it could be the passenger. Okay, so here's another hypothetical. Is this robbery? Dell walked up to Vic on the sidewalk at night with his finger in his pocket, pointed to Vic. He said, "Give me your wallet if you want to live." When Vic took out his wallet, Dell grabbed it and ran away. Okay, so again, just based on your limited knowledge of crimes, right? We have theft. Okay, let's just give it that, right? He took something, property that wasn't his own. That's the generic, general, basic definition of larceny or theft, right? But let's go to the ones that we have discussed. Was this it's not a burglary, right? Because it wasn't from his home, a dwelling or a property. Was this robbery? Go ahead, Vicky. Vicky, do you want to chime in, or Paulina?
Yes, it was robbery.
Okay. And what was the factor, the element that convinced you?
It took the property from another person.
Yeah. And then remember, robbery requires what? Some sort of force or intimidation or threat.
Yes.
What's the defendant going to argue, anyone? For you, they're defense oriented. Let's see. Korush, am I pronouncing that right? How do you pronounce that? You're muted, dude. Can you unmute yourself? Oops, go ahead. I just moved it. I'm sorry, we went same time. Okay, go ahead.
Wonderful. They're gonna argue that he didn't have a weapon on him at all.
Yeah, that it was just his finger, and that's not really a threat, right?
Mhm.
So now put on your judge cap. What are you gonna say? Is that defense gonna work?
No,
Yeah,
because it still evokes fear.
Well, it's common sense, right?
Yeah.
If that was the crime, if that was a good defense, there'd be a lot more robberies. But great. So I think you're kind of getting the sense of it. That's really what law students do, and that's what lawyers do, right? But the scale gets larger, right? As the laws get more complex. Okay. Real quick, I think I'm sorry, I don't have a sense of time. Am I good to continue or no?
Yes, you
Okay.
have another 10 minutes or so.
Oh, good. Oh, good. I'm going faster than I thought. Okay, so here Deb is a mad gardener. I don't think I guess she's angry as opposed to crazy. Mad gardener knows that her neighbor Victoria is away for a funeral. She goes to Victoria's home to steal some rare garden gnomes she saw V buying at the garden center. Dee uses a nail filer to slip the catch on the back door and steps inside. She grabs the gnomes, but when the alarm goes off, she leaves without them. Dee is arrested, leaving the house empty-handed, but in the driveway with the nail file. So again, I want you to recognize like how concise this is, and hopefully, even with your early kind of understanding of criminal law, I hope bells and whistles are going off. Like, oh, this is what I would zero in on. This is what's important. This is an important fact. This is a rule of law or an element that we would discuss. Okay. So let's return back to this. So we have larceny. Okay. So that's pretty clear cut. But because we want to heighten these crimes, as a prosecutor, you're going to charge the broad array of crimes as well, right? You're not going to settle for the least punishable crime. So it's not a robbery because obviously this is the converse of the other one. They're going into someone's home, right? Someone's dwelling. Okay. So remember, we're kind of juggling the common law, which is the breaking and entering of the dwelling of another at night with the intent to commit a felony, versus the modern law, which is the entering of a dwelling or a structure of another with the intent to commit a crime, okay, at any time. Okay, so let's break this down. What's popping out for you in terms of discussion? If we were in class and we wanted to break down this fact pattern, what would you zero on, Brina?
I think probably there would be an argument there that she left without anything, so it's not really burglary, but like it's clear that there was an intent to deprive.
Great.
So I would say it satisfies, yeah.
Yeah. Yeah, but that's a good argument, right? It's like, hey, I left empty-handed. I picked it up, but I didn't do anything. Okay. And you'll learn in criminal law that that's not going to be a good defense, although your instinct was she's not going to be successful at it, right? Because we're not going to require the actual harm to occur to punish someone for crimes, right? Necessarily. Okay. And is it Wami? I'm sorry,
Wamia,
Wamia. Great. I've never
thank
heard
you.
that name. I like it.
I think
Wamia.
thank you so much. I think she can be charged with attempted burglary.
Oh yeah. Okay. Yeah. Great. I mean,
The intent is definitely there,
yeah, yeah,
but because of the alarm, it deterred her from committing and going through with the crime.
great. That's actually beyond the scope of this exercise, but your instincts are very right because you zeroed in on an element and you said, "Oh, the alarm." She abandoned it, right?
Mhm.
But we're going to say that the criminal law is much more complicated than that. You're going to have to know if she's met. There's going to be certain elements for abandonment, okay?
Mhm.
And then also part of the abandonment element is usually it's not a successful defense if you abandon a crime because the cops are coming, okay? Because they're kind of like, well, if the cops didn't come or the alarm didn't go off, you would have done it anyways. Remember, it goes back to that fundamental, what was in V's heart or in Deb's mind, right?
Mhm.
She did have that intent and she did
The
have the crime.
intent.
But you're
Yeah.
right. But the attempt is a whole um, a whole discussion of category of crimes that you will learn, and it's kind of like you start with the crime itself, and then you see if it's unsuccessful whether it satisfies the elements of attempt. Okay, Tara, what were you going to say?
That's the question I was going to ask.
Uh-huh.
So, so it's good.
Yeah. But
At
yeah,
the very least, that's what they would charge you with.
yeah, you're on the same wavelength. I think as a former prosecutor, I would charge both burglary and attempt burglary. And in the real world, the reason why prosecutors charge so much, it's not to be punitive. It's really a practical reason. Is if I've got 7 charges, it's going to lead more likely to a plea agreement, right? I'm going to drop 5 charges if you plead to these 2, right? Um, I have, I think we could have different opinions on that, whether it's you know the best way for criminal courts to operate. But like I said, as a former prosecutor and a former defense attorney, I recognize the utility of it. It's really to, um, it's not necessarily only to be punitive. Some of it is very practical because I can't ethically charge a crime if I don't think I have enough to support it. And if at some point I realize a fact pattern where I can't support it, ethically I should strike that charge. But I think the way it works now, does anyone know statistically how many percentages of criminal law cases generally settle with a plea bargain? Or flip it around, what percentage goes to trial? Anyone want to venture a guess? Just go ahead. Is it Simone? Simone?
It's Simone.
Yeah.
Maybe like 65%.
Yeah. Oh, Simone, you're so optimistic. Anyone else? Yeah, it's much higher. I want to say it's at least in the 80s, if not the 90s, if I recall. The DOJ publishes that, and then I think the state courts do as well. If I think correctly, if I last remembered, it was in the 90s. Okay, or conversely, I remember the amount of cases that go to trial are in the single digits. And again, I think you're free to decide, you have an opinion on whether that's good or bad. I can say that, the criminal justice system is not necessarily about justice sometimes. Having, if you live in a very populous area, the prosecutors, they would not be able to function if every case went to trial. It's just logistically impossible. And the judges don't like it. No one likes it, not even defense attorneys. They don't like to go to trial either. Okay, anyone else want to comment on this last fact pattern? How about using the nail file to slip in? Is that enough for burglary? Definitely modernly, it doesn't matter, right? Go ahead, Paulina.
The nail file does help because it was for forced. So
Yeah,
that's
yeah. Especially modernly, it's more broad. And then, her argument is like, it was just nail file. I just like, I didn't use force, right? Were you gonna make a comment, Mia?
Yeah, I was going to say that it shows force and intent.
Yeah. Oh, yeah, great. Usually intent, we want to try to dive into what's in their mind, but it's often bolstered by their actions. Okay. But you can see how if we only had action, it would be self-fulfilling because the action would always justify be basis for the intent. So we usually have to dig a little bit deeper, right? Here, unlike real life, we're told, she coveted these gnomes, right? In real life, it's a little bit more complicated because we're going to have to the prosecutor's going to have to present circumstantial evidence, right? Isn't it true that your neighbor bought a series of rare gnomes recently? Isn't it true you saw her buy those? Isn't it true that you coveted those gnomes or you wanted those gnomes? Isn't it true you're known in the neighborhood as the neighborhood gardener? That's your identity, right? So then we fill in the gaps and go, based on that, we can infer that the intent was there. It can't always just be based on the action because that would be self-fulfilling all the time, right? It's got to be more than that. But it's usually a combination of it, right? One kind of supports the other. Okay, and then we discussed about the fact that she didn't get away with it. Go ahead, Wamia.
I was going to say it shows that it was premeditated.
Yeah, very good. Again, that is using an action to support an argument for intent. Again, intent is the gray area because it's literally in someone's mind, right? Because all she has to do is take the stand, which obviously is not always recommended. But what happens when she takes the stand? She said, "Yeah, I did do all those actions, but I never intended to steal the gnomes. I just wanted to touch them." Right? Then the prosecution got to come back and refute that, right? It's not as simple as that, but it's an example of how the action alone is usually not going to be sufficient. You're going to need other circumstantial evidence to get into their brain, into their mind. Go ahead, Kurush.
Yes. At the very least, wouldn't that constitute breaking and entering and trespassing?
Yeah. Those are all lesser included, and again, you'd charge those as well. Trespass for sure, just like larceny, and that's why the plea bargaining is going to be more appealing. And there is always a risk, right? If I want to go forward on the burglary, I might lose as the prosecutor, right? So then sometimes society benefits by saying, hey, he's going to plead to a trespass and he's going to have a reduced sentence or be on probation, but that will serve a purpose, right? He'll be on 18-month probation. He won't commit any crimes for 18 months, as opposed to going to trial and then, a jury, for some reason, they love gnomes and they sympathize with them, right? I mean, the jury doesn't have to follow the law. I mean, we can't guarantee the jury's going to follow the law. They're entrusted to, but they can, we read about verdicts all the time that we kind of scratch our head, right? And so as a prosecutor, I'm not going to take that risk, right? Necessarily. Okay. Anyone want to chime in here? Anything, last thoughts? Okay, here's a multiple choice question. Glenn waited all day to get his cable box back from Chuck, who had borrowed it to watch a blacked out football game. When Chuck hadn't returned it by 11 p.m., Glenn, fed up, went to Chuck's house to retrieve it. Chuck wasn't home, so Glenn went in through the patio door and took it. Glenn knew Chuck never locked his patio door. Again, very concise fact pattern, but you can see, I hope you're already getting that spidey sense, like, oh, he went through the patio door, okay? That was there for a purpose. It's to show that he didn't break or enter, right? He went in through an open door. But then you have to take it the next step. Well, is that trespassery entering enough, right? Did he have permission to go there, right? And then all these other elements, what was his intention? What was his intention when he went in there? So let's look at the multiple choice options. Did Glenn commit burglary? A, yes, because Glenn broke and entered Chuck's dwelling at night. B, yes, because Chuck had lawfully obtained possession of the cable box from Glenn. C, no, because Chuck left his patio door unlocked. D, no, because Glenn entered for the purpose of recovering his own property. Now, depending on how far removed you are from classroom and multiple choice tests, this might be causing you anxiety and triggering post-traumatic distress disorder. But it's a reality of law school and the bar exam, right? You are going to have to study for multiple choice questions, whether the last one you took was 5 years ago or 10 years ago, right? But that's what we're here for, to prepare you to be able to tackle these type of questions and relearn the ways to answer these questions under, within the law, okay, what we're looking for. And, this is a very textbook multiple choice question, 2 yeses or 2 no's. So everyone is probably immediately going to be able to narrow it down to A and B or C or D. And then it always come down to the last two. Which one, right? And then, of course, you only remember the one where you chose the wrong one, okay? Does anyone want to venture A, B, C, or D and explain why? Yep, go ahead. Rena?
My gut tells me it would be D because it's his own property,
Uh-huh.
but I would really want to know if they had an existing agreement of when he would
Oh.
return it.
Okay, great. Good. Any Karush? You're muted.
I want to say B, because even though it was in his possession, he lawfully lent it over to him, and he
Yeah,
unlawfully broke into his home to get it back with the
great.
intent of retrieving property that was in his possession, even though it was belonging to him. It was the rightful owner.
Can I ask you what you do for a living?
Me, I'm a teacher. I'm a special needs teacher.
Okay. No, because you zeroed in on possession, which usually it means someone who does something where possession is distinguishable from ownership. So that's why I was curious. Great. Anyone else? Anyone for A or C? Anyone want to support B or D? Build on. Okay, so obviously you're going to learn strategies on how to approach this question. The correct answer is D, but I actually think B is a very good second choice. In fact, if I had chosen B and got it wrong, I would appeal that and I would contest it and I would argue it. But actually, D is the best answer. Don't you hate that when the teacher said that? It's like, oh yeah, well B is right, but D is a better answer. Okay. It's like, yeah, well, you wrote it, so you're biased. But let's break it down, okay? It seemed like everyone was pretty readily eliminated A and C. And that's what multiple choice is, right? Eliminating the bad answers. A, yes, because Glenn broke and entered Chuck's dwelling at night, okay? I think what tipped it off, for me at least, was the at night thing, right? We don't have the statute. Sometimes the question gives you the statute, and that would be too easy. But, you recognize that dwelling at night, the emphasis is on it at night, and it's like, well, is that really relevant to whether or not he committed burglary? Because modernly, it doesn't matter if it's at night or not. But more importantly, the breaking and entering, right? I think again, it's not a clear slam dunk for breaking and entering. He's going to say like, "Hey, this is my neighbor. I go in there all the time," right? And Brina kind of suggested like, what was the agreement? Like maybe the agreement was, "Oh, you come by tomorrow and get it. If I'm not home, just come in." Right, but maybe Glenn just got impatient and went in earlier. So yeah, I think there are ways to support A, but ultimately I think that it does not seem as complete as some of the other options. And then C, because Chuck left his patio door unlocked. I think that one we've discussed and we've seen examples, right? It doesn't matter. It doesn't need a physically breaking down of the door, right? And yet maybe it goes back to the earlier point. Did he have permission to enter? Okay, but the way it's written, it says unlocked because it's trying to point out like, is that relevant? Does it matter? And he knew he never locks his patio door. Okay. So it wouldn't make sense to say like, just because someone never locks his patio door, that anyone could just arbitrarily walk in and take whatever they want. Right. That's not good, good for society. Okay, let's break down B. Yes, because Chuck had lawfully obtained possession of the cable box from Glenn. I understand exactly where you're coming from. You're saying Chuck had lawful possession because Glenn gave it to him. Said, hey, you can use this, right? And I'm basically going in and, you know, because Chuck is in possession of it, I did not give you permission to take it, right? And even though Chuck doesn't own it, he does have to give consent to take it. I think that's totally reasonable interpretation. Okay, but D is the better answer because I think I want to reemphasize, we want to know what their intent is. A doesn't talk about intent at all. B doesn't talk about intent at all, and B, it does touch on intent a little bit because how can Glenn deprive Chuck of something that's not his? Permanently deprive him of. It's only possessory. And then D, because Glenn entered for the purpose of recovering his own property. Okay. That is the sense of, at the end of the day, it's not as simple as self-help, but I think it's analogous to that. It's this idea that, he didn't have the intent, kind of like what I just said. He didn't have the intent to deprive Chuck of anything that he had a lawful right to, right? Chuck's lawful right to the cable box is dependent on Glenn's consent, right? Because Glenn is ultimately the owner and Chuck is in possession of it. Okay, does anyone want to, I think maybe a couple questions specific to criminal law or this exercise? Anything you're curious about? Anything you want to expand on, like how would this look in a real class or how would this fit in, what it would look like? We're trying to give you a glimpse of what a lecture would really look like. And then also the format and also, to the point made earlier, it really depends on your level of interaction. I've had classes where there's a low level of interaction and some with a high level. And I think it's all good, right? It depends on what sparks your interest. But I will say the more engagement, I think the better your experience will be, and also the more achievable the goals are going to be. But anyone want to ask me a specific question about criminal law in general or criminal law class? It is one of your core classes because it's double tested on the bar exam. So you'll likely have an essay on criminal law and also multiple choice questions on criminal law. So it is heavily emphasized in law school, in all law schools. Okay, very good. I think I'm going to turn it over. Oh, I'm sorry. Burglary, robbery and burglary both involve theft. Again, it's that umbrella of theft, or larceny. But robbery is a specific crime against the person, while burglary is a specific crime, is a property crime. They're subsections of theft, right? And then we have carjacking, which is a subsection of robbery because it's a particular property. And you can see how it got narrower or broader depending on what the legislator, what their intent was, right? The carjacking, because it is so serious, it's such an egregious kind of crime against someone's personal safety, the sanctity of their car. We're going to, have it broader. We're going to make it broader, right? It's going to be, we want to, not just be punitive, but we want to work as a deterrent, right? Don't go for joyrides. Don't steal people's cars, right? And you can see, similarly, we're going to heighten punishment for crimes against, in someone's home, because where else, if you can't feel safe in your home, if someone's going to be so brazen as to commit a crime in someone else's home, we're going to punish them more severely because society is going to frown more upon that, right? Okay. I hope that's the last slide. Yeah. Okay. Any questions? I should throw my email. I'll throw my email in the chat as well. And then if you want to email me with any specific questions, I'll be glad to help. But we're going to turn it over to talk about specific questions or the procedure for admissions. I was happy to hear that several of you are already admitted. So congratulations. That's really exciting. And I can manage the slides, continue to manage the slides if you need it, or if someone wants to take over.
Oh,
and
that's
sh-
great. Thank you. Thank you, Professor Chow. Thank you very much. Can we give Professor Chow a nice little, thank you. And to all of you who participated in the program. Oh, Paulina, that's very good. I see some hands going up. Um, we have with us tonight Danya, who I know that many of you know. Danya, do you want to chat a little bit about the process,
Absolutely.
where we stand in the process and so on?
Yes, thank you. Thank you, Professor Chow. That was wonderful. I don't think you scared too many of them, so it was wonderful.
Oh, darn.
Yep. And you too, Professor Brandis. You might be on the dark side, but once a professor, always a professor. Thank you. So yeah, I definitely have spoken to almost everyone here, and some of you will be even starting classes here shortly for summer, and then there's even more of you that are ready to go for fall. So during this Q&A that we'll hold until, let's see, 7:30, you can ask questions to the professor, or you can ask questions about the admissions process. I did earlier in the chat leave my direct email that you can reach out and we can have a one-on-one conversation, either phone call, Zoom, or email. But real quickly, I will cover these dates that are in front of everyone. For the fall classes that start, the application deadline to submit your application is June 15th. And then you'll have till June 25th to submit all official documents. Orientation will be early in August. It's going to be online. So all first year law school students, no matter what campus you are attending, or if you're an online, you will all have that same orientation of the 3rd through the 6th. So 4 evenings in a row, and that will be 6:30 to 8:30. And then of course classes start week of the 17th. So that's some good information to keep track of. And then the next slide is going to give you another, I believe, email address that you can also capture, take a picture with your phone. And let's see here. Yeah, you can go ahead and also send any questions to that email address. So let's see, you can submit your questions either through the chat. We've got 2 assistant deans in the background that can answer questions. You can raise your hand. And again, those questions can be directed to the professors or to myself regarding admissions. So feel free to ask away. I'm going to check out the chats right now. Dean Dowsett has attached our catalog. That's going to be very helpful. Let's see here. What else do we have? Can you repeat what are the times for orientation? Yes, they are going to be held 6:30 through 8:30 in the evening, and they're online. So even if you're an in-person student for the fall, that orientation will be online. And let's see here. Okay, that catches us up on our chat questions. And then if anyone has any others, feel free to unmute and ask away, or you can raise your hand, whichever you're comfortable with. Or not.
Danya, I'll just say, while people are thinking for a moment about orientation, it is so cool, actually, to go in and start kind of wrapping your head around how you're going to do things. I mean, we did a
Yes.
little bit of that tonight, but orientation has a lot of that.
Yep.
And even skills, like more of the kinds of skills we very briefly touched on during the course of our segment tonight. How do you actually brief a case, and how do you conduct an ARAC analysis, and all those things? We actually start getting into that right away in orientation. So for those
Excellent
of you
point.
who are signed up and excited
Mhm.
about getting going, there's a good reason. There's really good stuff there.
Absolutely. That's a good point. There's even bar prep information. So we start the brainwashing early. So there is going to be a mini orientation for the summer folks that are starting. Week of the 18th, they'll have an hour and a half orientation, getting them ready for those 2 classes. But yeah, there'll be a way more in-depth one, prepping everyone. Absolutely. Okay, so Dina's got someone has asked a question. will you get an email to the email address? I'm not sure if I'm catching this one. Dina, can you go on mic to answer that question?
Yeah, so the question was, how will you be notified of the admissions committee's decision? And usually you will sometimes you'll receive a text message letting you know a decision has been made, followed by an official email, again, letting you know of that decision. After an application goes to the admissions committee, it takes about 7 to 10 business days before the decision is reached and the applicant notified.
Thank you, Dina. That's great. And to add to that, so we look at the applications on a rolling basis. So it's not like we wait till June 15th and then look at the applicants we have. So the earlier you do get that application completed with all the official documents in, we can review your file. So that's an important thing to know. And then Dina, yes.
I have the answer to this next question here. Will the
Yay.
summer course material be available and popular before May 18th so we can prepare for the first day of class? So there's a couple layers here. You already have access to your classes. You can check out the syllabus, and the required books are on there already. And then materials are actually going to open up. Our goal is May 11th. For those materials, but you can already look for your books, check out the syllabus, and then materials shooting for May 11th.
Excellent. Thank you so much for that. That's wonderful. Okay. Let's see if there's anyone else there. Okay.
Danya, there's a question
Yes.
about applying with 60 semester units.
Thank you. Well, I'm not as good as the professors are at these multiple screens. Okay, I read that we can apply with at least 60 semester units. Are there any specific classes we need to take? So yeah, to apply as what the state bar calls a regular student, you need 60 academic transferable units. It doesn't specify if there's any classes that should be in there. They just need to be transferable. So there's remedial classes that wouldn't count. Anyone that has a body of units and it hasn't got to the associate's degree or culminated in a bachelor's, we usually recommend they get those units evaluated through the state bar. Okay, and hopefully that answers that question. And again, is it Elena? You can contact me. We can have a chat about that, your specific situation. Happy to help you through that.
The registration link for the May 11th orientation should be in your school email address. If you don't have it, you should have gotten an email from me introducing myself. Feel free to please reach out to me with any of those kinds of questions. I'll help you through any of the process in your 0L year and your 1L year. And no question is too small or too big. Please see me as a one-stop shop for any of that, anything in your first year.
Yeah, and to add to that, all your emails now, just to reiterate what Dennis is saying, are now going to your new email address that was set up. So we're no longer using your personal email for that information. Okay. At this point, I'm going to turn it over to you.
Okay.
And
thank you, Danya. Yes,
You're
thank
welcome.
you to everyone for your great questions. And most importantly, thank you for being part of the evening. Professor Chow, thank you again for helping us with the con law class. And to all of my colleagues, Assistant Dean Dowsett and Assistant Dean Meffert. We have a great team here. You can see they're here tonight to help you with this, and they're here when you get started as well. And they'll all be around to support you as you have inevitably, kind of new student things that come up that you wonder about when you get started. Law school is that way. It is a little different from some other education that you might have undertaken. So things will come up, but you've got a great team to help you. If there's no other questions, doesn't look like there are. One last chance before we say goodnight. Okay, well, thanks to everybody for being a part of it. We look forward to seeing you in the school one of these days. We're very excited to have you if you're ready to join us, and if you're joining us in summer, that is. And if not, we'll look forward to hoping to see you in the fall. Thanks, everybody. Have a great night.